Welcome to the Global Happenstance. On this channel, we react, reflect, and respond to the trending global events. From shocking headlines to inspiring moments, we break it down one reaction at a time. Stay with us and don't forget to like, comment, share, and subscribe.
Indigenous people of Biafra and Nnamdi Kanu, and proudly so, Kenyan High Court, before which Nnamdi Kanu had brought a legal action over this extraordinary rendition. So finally, we have the government of Kenya through an affidavit drawn up and filed by the Attorney General of Kenya, stating clearly, without any equivocation, that there was no record of departure of Nnamdi Kanu from Kenya from when he entered Kenya. So this is the clearest confirmation yet, beyond media razzmatazz. This is now inside the record of the court of Kenya, that the Kenyan government is on record with such significant denial. So you can say that Nigeria has finally been thrown under the bus by Kenya. This denial, whether true or not, makes the case of extraordinary rendition of Nnamdi Kanu much stronger than it was before. That's number one. Number two, it has created a panoply of possible criminal violations that will ensue on grounds of the anti-torture legislation of Nigeria and the United Nations Convention Against Torture, and of course laws of Kenya. So right now you're looking at a situation where criminal indictments may lie against those people that participated directly or indirectly in the abduction, unlawful imprisonment, disappearance, torture, and the ultimate rendition of Nnamdi Kanu to Nigeria. So while we were hitherto, while we were previously talking about extraordinary rendition as a barrier to his prosecution in the Abuja criminal matter that is pending, we're now talking about a situation where you have very serious crimes committed within the domestic laws of Kenya, domestic laws of Nigeria. Like I mentioned before, Nigeria has a law prohibiting torture, and within the canons of international law. So these criminal proceedings will have to be activated. We are lawyers, so we are going to pursue this to the hilt. We are trained to pursue the path of justice. So within Kenyan national jurisdiction and Nigerian national jurisdiction and the international arena, you can expect that there is going to be a levying of sort of myriad criminal indictments to follow what happened. It was a very terrible thing. Someone entered, and we have it on good authority. Kenyan immigration records still indicate that Nnamdi Kanu is still in Kenya, because I'm sure somewhere along the line the British authorities will stumble on this information. So it opens a new vista of diplomatic interventions by Britain that has the right, based on the nationality, British nationality of Nnamdi Kanu. Britain now has a clearer right to demand of the Kenyan government what happened to Her Majesty's subject, Her Majesty's citizen who entered your country on 12th May 2021, but then suddenly found himself in Nigeria. I think a lot of questions will have to be answered here diplomatically and criminally. That is a very, very important development in the case. It makes the countervailing motions that have been brought before the Abuja High Court stronger. Of course, it adds.
Kenya court ruling. Rendition was unconstitutional. June 2025. Britain's decision to remain silent may be a calculated strategy. Nnamdi Kanu is a British citizen, and his 2021 extraordinary rendition from Kenya should have triggered diplomatic outrage. But the UK government has remained quiet, only offering minimal consular visits. This silence has fueled suspicion that Britain may be cooperating with Nigerian authority behind closed doors to maintain political or economic stability. Positive moves: 1. Preserve diplomatic ties. 2. Avoid setting a precedent for international intervention in African political matters. Let's listen to Aloy Ejimako.
Of supposed or purported jurisdiction. There is nothing like interception known to either international law or municipal law. What is known to international law is extradition. Putting on rendition has opened the door for the federal government to come in and explain to this court how they managed to bring Nnamdi Kanu before the court. That barrier, that bridge has to be crossed before any trial, any proper trial can ensue. Thank you. Court case in Kenya is making its way through the system, but it's a constitutional action, it's a civil action. But this very affidavit, this latest affidavit has opened a new avenue for a new action that is going to be grounded on criminal violations. So if Nigeria went rogue, went into Kenya and violated the territorial integrity of Kenya, it's for Kenya to say clearly that that's what happened. But you see, it beats the imagination. It's quite unbelievable, incredible that one nation will go to another with a private jet, take someone and exit the international airport of that nation without any let or hindrance. That is very hard to believe. But the whole truth, I think, will only be unraveled if some kind of criminal investigation is open. The details of that, I cannot get into the details on camera.
Yes.
Well, anyway, you see, we are always going back to the drawing board. Every new development leads to a rethinking of the strategies for defending him before the Abuja court. You raise a very important point that will come into consideration. But I think the next point of action for us is to see how his bail is going to be reinstated and a new bail approved for him by the court. We believe that he's qualified for bail right now, that we have a consideration, a determination by a court of competent jurisdiction, but that what happened in 2017 that brought him or compelled him not to attend court in 2017 was not his fault, but the fault of the federal government. So it used to be that Nnamdi Kanu was a bad guy, he jumped bail. But right now, with the pronouncement of the Kenyan High Court, it is the federal government that is the bad guy. They are the ones that made him to jump bail. So I don't think any court should allow them to benefit from their own wrongdoing. That will be inequitable. That's our position. Well, anyway, first of all, the federal government has not appealed the ruling. A lot of people were wondering if I have received any notice of appeal. I'm seizing this opportunity to say that I haven't. I don't mind. The federal government has the right to appeal. I hope they won't, because they're a very good judgment. Well, we don't have the 1 billion yet. If we had the 1 billion, it's a very hefty sum of money. I think everybody will pretty much know about it without asking me about it. But that 1 billion is not really the issue. The issue is to clear Mazi's name, to clear Onyendu's name. It wasn't a question of money. There's no amount of money that can ever qualify. As a matter of fact, I regard the other two pronouncements by the judge as more valuable than the 1 billion. The other one that required the federal government to apologize to him and publish the apology in national dailies, and the other one that recommended to the federal government to pursue the path of peaceful political solution to this matter of self-determination for Biafrans. It's not a matter for tough law enforcement. It's not a matter for arrest, prosecution, rendition. That's what the court seems to be saying. That is far more important than the 1 billion naira. Nothing can ever compensate for the emotional trauma, psychological and physical damages that were brought upon this family and upon Mazi and his parents and the 28 people who lost their lives on that ill-fated day or ill-fated period of between 10 September to 14 September 2017. No amount of money can ever recompense or compensate or remedy the terrible situation that was created. I think the victory will lie full policy somersault and telling itself we have been wrong all along. What we need to do in this situation is to call everybody to the table and seek political solutions to this. That IPOB and members of IPOB and Nnamdi Kanu are not criminals, but people who are genuinely agitated about the injustices in the system, which can only be addressed through dialogue, not tough law enforcement. What I can tell you is this. Listen, I came into the picture in late 2017. I was called upon to represent IPOB and Nnamdi Kanu when he was missing after the September 17, 2017 attack. I had contact with his family members and they brought me into play. So I want people to understand that from that late 2017 to now, I have 2 victories under my belt. There was a victory I won at the continental level. I'm not going to the details, you couldn't do the details of that victory because we are forbidden to do so through a certain article. That decision is a continental decision and it's not supposed to be discussed in detail. That's one victory, and there's a lot of assurance in that very decision that affects backwards adversely the declaration in Nigeria that IPOB is a terrorist group and the proscription and everything that has happened to members of IPOB and Nnamdi Kanu since August 2015 was condemned by that decision. If that decision was implemented as we expected to the letter, Nnamdi Kanu would not be in detention right now. A lot of IPOB members wouldn't have been in detention. Those that died wouldn't have died. So I'm seizing this opportunity to call on the federal government. You are aware of the decision. A letter was written. The Attorney General is aware. The President is aware. The Foreign Minister is aware. I'm calling on you people to implement that decision because Nigeria is a treaty member of the continental body, the international body that took this decision. It's very roguish, very irresponsible for a nation, any nation that signed a treaty, not bound by the letters and spirit of that treaty simply because a decision has been taken that that nation is in breach or violation of provisions of that treaty. It's very irresponsible. And I'm not mincing words in saying it. So Nigeria needs to exhibit or demonstrate responsibility of a state by implementing that decision that was taken internationally. That is one victory that I got, and I'm very proud of it. And I think members of IPOB need to be comforted that an international body listened to their cry and the gavel fell in their favor, that they won. Then the second one under my belt and under your belt, I dedicate everything to the members of IPOB, to Nnamdi Kanu, is the Abia decision of 19th January. That's the second victory. If Nnamdi Kanu did something wrong in 2017, why would a competent court turn around and say, no, he didn't do anything wrong? That is the federal government that did something wrong. So you have to think about that at individual levels, at your individual levels as members of IPOB. Of course, I will encourage you to be law-abiding. But what the system seems to be saying, the domestic court here, that domestic decision from Abia State and the one from the international tribunal appear to be saying is that self-determination is not a crime. That is what it's saying, pure and simple. Because if Nnamdi Kanu was engaged in a criminal enterprise, the Abia High Court would not have agreed with the proposition that the federal government's controlled armed forces went to his house to terminate his life, to borrow the language of the court. So while I encourage members of IPOB to be law-abiding, I would not, as a lawyer in good conscience, encourage any member of IPOB, or in fact any Nigerian, to deny himself his fundamental human rights. You have a right to protest. You have the right to disagree with your government. You have the right to demand better governance. You have the right to hold the political opinion of self-determination. self-determination is a political opinion, and chapter 4 of the Nigerian Constitution protects political opinion. So I'm not going to be here to tell anybody to be a wimp and cowardly about his rights. As a lawyer, I will encourage you to be law-abiding, but don't sleep over your rights.
I understood, not I understood. Nnamdi win the war. I understood, not I understood. Nnamdi go onye do I more. O Mary wone nizu Giroya Abakare Mama Ndamura. Nnamdi win the war. Python that's one, Python that's two. Now Python that's the three. Nnamdi win the war. Python that's one, Python that's two. Now Python that's the three. Nnamdi win the war. Python that's one, Python that's two. Now Python that's the three. Nnamdi win the war. Python that's one, Python that's two. Now Python that's the three. Nnamdi win the war. Python that's one, Python that's two. Now Python that's the three.